Very good afternoon to all of you. Myself Prashant, working as an associate professor in the Department of Electronics and Communication, IIMT Group of College, Noida. Today I'm going to give a lecture on intellectual property rights. First of all, the thing is that what is the intellectual property? It is defined as the property of human mind of thinking towards a new idea or towards you can say new innovation, towards the new creation. If we talk it in terms of development, in terms of technology, the every new idea, every new thinking, every new aspect which comes in your mind, but the thing is that it is for the public use. It is for the you can say in general for the industrial or for the public demand or for the public commercial purpose. If we talk in terms of labor, we can say it is a product of individual capability and dedication towards a new area. You can say when we talk about the new area or new era, that means the things which are currently latest and they are towards the industrial point of view. Because if we talk about the growth, will from the starting will grow gradually, step by step. So for this, IP just like steps. Certain steps we must have to follow to bring it in the public domain. So if we talk about the first of all, the first basic thing about towards the IP, that is creation. When you talk about the creation, that means everybody has some God makes man as a creative. You can say everybody has its own creation, innovation, and when creation becomes innovation, then it must be commercialized. And once it gets commercialized, it must be protected because the mother of invention must be always honored and it must be protected. And after that, protection is not sufficient for the enforcement. That means planning a good thing is different thing. Making a good thing is different. But up till and unless you can't implement it for the public use, it is useless. Now, if we talk about the intellectual property, what are the different types and what are the things which comes under the intellectual property? First, copyright. Second, your industrial property, trademark, trade symbol. You can say patent, industrial designs, symbols, confidential information. It's most important because something is like that. Certain information we must have to protect them. If we talk about in terms of information, data, everybody is saying for the data and everybody is working for the information. So when we talk about the data, they're just talking about the zero and one in terms of to protect our information, and that must be confidential because every company, every person has some own idea, some own thinking, and that must be confidential for his or her growth. Now, one more thing is added to in geography. If we talk about the geographical topic in this, because the new, you can say, Iceland, new area, up till now, we can't reach there. But once the Google comes, we know about all these. So, if we talk about the IP, it's very important about the intangible and tangible things. If we talk about the tangible property, you can see the word itself indicate intangible. That means that must be transferred from one person to another person. If we talk about the examples, it may be land, it may be house, it may be money, it may be assets, it may be car, vehicle, etc. But we talk about the intangible that can't be transferred, owned for himself. If we talk about the examples, the best example is wealth. Easily appropriated, reproduced, once created, marginal cost of reproduction, and it is negligible. You can see the creation of human is the best example towards the creation era. Now, if we talk about the why, what is the need of protection of IP? The thing is that first, if we go for the new things, we need certain expenditures, and that must be needed by individual. So first, capital expenditure for new products. Then after that, we go for the R&D work, new research and development. As I earlier said, mother of invention must be honored and protected. Marketing and advertisement. That's why we need protection of that because everybody or every company, every product have its own marketing strategy depending on the segmentation, depending on the production, or depending on the cost and certain factors are to be there. And if we talk about the advertisement, it is very important. Day before yesterday, I just coming from any place, so I saw a slogan backside of the पब्लिक व्हीकल, जितना प्रचार उतना व्यापार. That means advertising is the core thing that you must globalize the things to get your protect, जो प्रोडक्ट आपने बनाया उस प्रोडक्ट को एनहांस करना चाहिए. देन नो फ्री लोडर्स. आफ्टर दैट मेंटेनिंग लॉयल फॉलोअर्स हमें मेंटेन भी करने की जरूरत होती है. एंड मोस्ट एवरीबॉडी इज लुकिंग फॉर द प्रॉफिट आल्सो. सो फॉर दैट वी मस्ट प्रोटेक्ट द आईपी. आईपी दैट मीन्स योर intellectual property or idea for which you are going to work. Now, some international conventions are to be there which are required as we go for the development. It was the decade of early 70s. So we have 3 or more conventions to be there to protect the IP at a global level. First is Paris Convention for the Protection of Industrial Property, and 1967. Later on, it is amended in 1989. Then Venue Convention for Protection of Literacy and Artistic Work. It may be your dance, it may be drama, it may be music, it may be your lyrics and like that. Then after that, at the international level, the trade-related aspects agreement, which was comes in a global domain in 1994. Now, Paris Convention covers the objective. What is the objective of Paris Convention? Protection of industrial property, trademarks, patent, unfair competition, and if we talk about the government by the domestic legislation. Now, if we talk about the, you can say, characteristics of your invention, characteristics of your IP, characteristics of your patent. There are 3 major characteristics for that. If we talk about the characteristics, then first is your idea must be new. It must be new and created by you yourself own. Now, if we talk about this, it must follow the invention steps. There are certain steps that must be followed to get your invention. And last and foremost, if we talk about that, it is for the industrial and public application. That is must. Now, Venue Convention is for the property of it, as we discussed earlier, for artistic work, maybe music, maybe your lyrics, maybe your short movies and like that. Now, there are different laws which must be formed to protect your IP. Now, if we talk about the law, Copyright Act 1987, Trademark Trade Symbol Act 1976, patent, very important for that, it was common in the legal domain in 1983. Industrial Design Act, because a lot of companies are making the same product, but their designing concern is different. Depending on the design concern, their cost, their marketing strategy, or their product life cycle may depend. So for that, this new era, industrial design, as all of you know, earlier the vehicles, if you talk about the 4-wheeler cars, their length depending on their length or weight, sometimes their cost, sometimes their taxes, they must be varied. Now, if we talk about then again, geographical indications that the demarcation of your sea or air areas. Now, if we talk about the most important law of tort, if we talk about the torts, that means this comes from the Latin word tortum, that means twisted or proud. If you are, for your individual benefit, if you are doing the wrong thing by touching or by modifying some I can say your idea just to capture the other work, that is some tort. If we talk about the tort, there are 3 types of tort. One is your intentionally, second one your negligence, and third one is strictly liability. If we talk about this tort area, it is very important to protect your business, your idea, and your production for commercialization. Intention play very important role because there are, if we talk about the more towards the infringement that you can say it's the word comes from the encroachment. Infringement, there are 2 types of infringement of your IP, maybe copyright, maybe your patent, maybe your trademark, maybe your trade symbol. That is direct and indirect. Direct, if you intentionally misuse the other idea, other products, or other things for your personal interest, then it comes under the heading of direct infringement. And the second one is indirect infringement. That means if by mistake, by unknowingly, you use full or certain part of anybody's product or ideas, and once you realize, okay, you are doing the wrong thing, you stop over this and you go over there and apply yourself, then it comes under the unintentional. In Indian Constitution, if we talk about it in terms of tort, direct or indirect, Both remedies are to be there in the Constitution. Now, protection of patent. To get your granting a patent, it is very necessary to protect or to get your patent for your own innovation. The applicant applied to government, if there is a procedure to go for the patent, once he or she apply through application, then uploaded their supporting documents over there. There are 4 places all across India where you can go for the patent. It may 4 metropolitan cities just like Delhi, Calcutta, Chennai. Now, if we talk about the duration, it may be 20 years, minimum 20 years, or you can say up to minimum 0 to 20 years. Within that period, you have to just modify your ideas or your innovations. You are unable to do it, then it may be transferred to the another. But doesn't mean there is a clashes on that complement. Sir, initially you said it was intangible or tangible, but it is just transforming, not just your rights for new invention for the application of your older product. Now, if you talk about the patent, go for the innovations. You can apply it for the product all across your process. Sometimes you are making a product, and sometimes you making a process to complete a product that must be patented by you. Patent innovation must be new for new ideas is to be there. Means one more thing is to be there. There are certain characteristics for patent. First, your first and foremost, your idea must be new. It must follow some, you can say, invention steps to be there. Now, if we talk about this property date comes from whenever you are filing the application for that patent idea. Now, if you talk about the exclusive right, they are something different from your, you can say, protection or a part of that your what you are making and for what you are looking for. So if we talk about the exclusive right to control the whole or substance part of your work, maybe complete work, maybe partial work, maybe some partial work. To reproduction is any material form, because all of you know nobody can make product from A to Z. He or she have certain part to be there manufactured by here and some part to be manufactured by some another sister concern, and then they are assembled into the one I can say plant. The best example, iPhone. If you talk iPhone, on the box of iPhone manufactured by America, but in the bracket it is assembled in China, because जितने भी सारी चीजें असेंबल चाइना में होते हैं फोन के लिए, एंड प्रोडक्शन उसका कहाँ होता है, वो आपका यूएस में. If we talk about the communication to the public, it's one of the rights to be there. The public performance, showing or playing. There is 2 things: showing whether public are doing interest or making some interest, or they are just using your product as for their general purpose. So that must be important. Now, if we talk about the distribution of sales and other transfer from one place to another place and from one domain to another domain, or for one subcontinent to other subcontinent. Now, if we talk about the commercial rentals and public, the best example, warehouses. So to get warehouses, we have certain rights, and to have some confidential information about that warehouse. Now, enforcement, that play very important to the IP. If we talk about enforcement, as we discussed, civil as well as criminal, both protections are to be there to protect our IP. Now, if we talk furthermore about this, that is a civil action. Maybe your penalty, maybe you are blacklisted. Every time we are saying this company is blacklisted from the domain, that company is barred for 3 or 4 years, banned for 5 and 6 years, depending on their reproduction, depending on their services. Because if you make a good product, very good product, the best example is Maruti. Why Maruti is successful in India? Because their connectivity to the people, their services to the people. If we talk about initially we talk about the car, I forget the name, it's a very small car in segment from first car, Devo. So what is the reason behind that? To fill it that Devo in India, they don't provide the service to end-to-end user. Sometimes your product, sometimes their cost, and maximum time your services, because everybody is looking for the services also. So for that you have to have protection. The best example, consumer phone, which protect the human rights, or who can say consumer rights in terms of IPR. Now, if we talk about the cost of litigation, that is depending, because whenever you are filing to the going to the court, there are some fees to be there. You must deposit to that fees. Thing like that, if you go for a patent and copyright, some normal fees is to be there. First of all, you must deposit that fees over there, and then and there you are able to proceed. Now, enforcement division, assistance from the enforcement, because sometimes things like to be that if you are unable to implement your part, then you must be punished. Because if you are making the thing and a good product for the public, but you are unable to reach them, or your product is unable to reach them, then you must be penalized. Now, if we talk about the self-help decks and all these things, that may be the part of your process. Now, criminal prosecution, that is very important. First of all, you have to go for the making complaint, that is the primary step. First, you go for direct to the your end-to-end user. Then, if you are not able to satisfy your settlement over there, then you go for the police station to enforcement of your things. Now, cost borne by the government. Sometimes you have to go against the system also. So that is a part of your criminal prosecution. Now, some remedies are to be there. Maybe civil, maybe criminal over there. Maybe your prisoning, and maybe your fine imposing, or you can say depending on your crime and offense, what you are intentionally or unintentionally what you done. Then and there is some remedies are to be there, constitutional remedies to be there, which you have to just depending on your situation of, or you can say the degree of your crime. Now, IP infringement is most important. Infringement, that means, as we earlier discussed, encroachment. That means if your idea gets stolen intentionally or unintentionally by anyone, and you don't know about that. Once you go in the market and then you say your product is selling with half of your price and your same brand, and immediately you're stuck. What's going on? Something is happening over here. So infringement, as we discussed already, there are two types, direct and indirect. And if we talk about the intentionally and unintentionally, depending on this, you can say sometimes they are also known as primary or secondary infringement. Primary infringement, that means intentionally people are using your product, your ideas, and like that. How does it to how causes कितना आपको नुकसान पहुंचा पा रहे हैं, than making a product, maybe making a product, maybe selling a product, maybe selling a product, depending on this thing. Now, if we talk about secondary infringement, then again, unintentionally, whole product or part of your product, some people use this, and that may harm you, directly or indirectly. Now, the more commercialization activity. That it's a best example, franchisee. If you talk about the franchisee, okay, I am the just like the McD and Domino's. They have brand, they have their symbol, they have their trademark, they have their trade policy. One important is trade policy, trade secrets. The best example, Maggi Masala. A lot of noodles companies are there, but the recipe of Maggi Masala, people are using that for the vegetable also. So that is the commercial activity. So for that, you must protect in terms of their infringement also. Maybe direct, maybe indirect. Now, if we talk about the slogans, symbols, they all come under the heading of directly and indirectly. Recent development, maybe last week or last week, Amitabh Bachchan gave a petition in the court, and court decides, he says nobody can use the voice of Amitabh Bachchan without his permission, because a lot of things are to be there in the market. The people are just using their voice. No issue. At the local level, there's no issue. If people are doing the things just like that, they can impact on globally in the advertisement field. Once the things come on online, they become global. So to avoid all these silly things, maybe directly, maybe unknowingly, maybe intentionally, unintentionally, maybe to get your personal benefits, maybe to get harm to anyone. So these things must be protected from the infringement also. For that, we just have both civil and criminal remedies in our constitution. Now the other one is selling, distributing for sales, etc. Maybe selling and distribution, maybe reform, maybe production. So there are a lot of things we have to protect all these for the infringement. Now, if you talk about the secondary, the same thing intentionally and intentionally. They come from the thought that maybe sell, let's hire, maybe sometimes you are just making agreement for a company to use his or her symbol or his or her product for 3 years, and after that 3 months for the grace period. But after that, if you are just like that, the renewal, if you don't go for the renewal, then it's become illegal. And one more, another one thing, infringement, infringing copies. If you, the simple thing is copyright for your publications also. If you have given copyright to any publication for 3 years, okay, you are publishing my book and 100 copies per year and for continuous year. If he or she is going beyond that, if he or she is going less than, there is no problem. If you go beyond it, then it becomes a problem in terms of constitution, in terms of. Now, if we talk about the importing, exporting, all these things are to be. And now I will try to cover up all the things this particular lecture. Again, I go for the refreshment for them who join later on. So as we discussed already, it's a human mind and thinking towards a new idea and innovation. And in terms of productivity, you can say it is a capability and the product of capability and dedication towards a new idea. Creation, innovation, commercialization, protection, and infringement. These are the different type of IP properties. Then tangible, intangible, already we discussed the transferable or non-transferable. And then why protection is to be there, as I already said, we need some expenditure for a new product, we need for new finance or new ideas for the R&D, we need money for the marketing and advertisement and for maintaining the loyalty to get the profit. And one more important thing, as I earlier said, the mother invention must be protected to encourage the society towards a new innovation, towards the new digitalization, towards the new industrialization. Now there's some international conventions that to be a Paris Convention and Berne Convention over to be there. And Paris Convention that may protect object to the Paris Convention, maybe for protection of industrial property, trademark, patent, unfair competition, unnecessary without any is just like that a dummy candidate stand in the election just to divert the public towards them. And the best example is the no vote, no vote for anyone. If you don't like any candidate which is standing in your constituency, then you can press the button no vote. So it's like that in many convention that for the other artistic and literacy work that you go for the lyrics, your words, your music, your dance, your drama and all that. Now, certain laws are to be there, Copyright Act 1987, Trademark Act 1976, Patent Act 1993, Industrial Design Act in 1996, and Geographical Indications Act 2000. Just to protect your borders to be there at a sea level or you can see at a hilly area especially. And then it also already discussed all these things in terms of information, protection, patent already covered for the new inventions, new idea, new product needs to be there. Exclusive right, every rights to be certain rights to be given to you to protect your ideas and all these things. And proceed to the rights for that we go for the civil and criminal protection part. Enforcement must be there to get your product, to get your things in a legal domain. Maybe planning, maybe implementation. There are some prosecutions are to be there, starting from the settlement can go for the police. And then a lot of things are to be there. The best example is earlier covered the consumer courts to get the relief for the market. Infringement, you can already look at that directly, crime measures.